An anti-assignment clause prevents a contracting party from unilaterally assigning his interest to a third party. In Condo versus Connors, we discover what happens if a contracting party assigns his interest despite the existence of an anti-assignment clause. Thomas Banner, Thomas Connors, and George Roberts were members in the limited liability company, the Hutt Group. Hutt's operating agreement contained an anti-assignment clause expressly prohibiting any member from assigning any portion of his interest without prior written approval from all members. As part of a divorce settlement, Banner attempted to assign his rights to receive distributions from Hutt and effectively his voting interest in Hutt to his ex-wife Elizabeth Condo. Banner drafted an initial instrument to this effect, but Connors and Roberts wouldn't approve it. Banner then drafted a second instrument without reference to the operating agreement. Banner didn't seek Connors's and Roberts's consent and filed the second instrument with the divorce court. Upon learning of the second instrument, Connors and Roberts expressed their concerns to Banner. After some negotiation, Banner agreed to sell his interest to Connors and Roberts. Condo sued Connors and Roberts, claiming tortious interference and civil conspiracy, but the trial court determined that the underlying assignment was void because Banner made it without consent. The court granted summary judgment to Connors and Roberts. The appeals court affirmed. The Colorado Supreme Court granted cert. Condo argued that the anti-assignment clause applied only to the transfer of duties, not rights. Alternatively, she argued that the anti-assignment clause placed a duty on each member not to assign without consent, but Banner still had the power to wrongfully assign his interest.